Welcome to today's webinar. My name is Cesar Juarez. I'm a member of the State Bar of South Dakota and the CLE committee. Before we get started, I'd like to go over a few items so that you know how to participate in today's event. Do you or a lawyer, law student you know, have a drug or alcohol problem or are struggling with depression or anxiety? Lawyers Concern for Lawyers is a confidential and independent resource for South Dakota lawyers, law students, and their families. Your referral or visit with LCL is strictly confidential and privileged. Call Becky Porter for more information at 605 391 5191. Becky is an LCL member, and your communications with her are likewise confidential and privileged. Today's presentation will last approximately 1 hour. You will have the opportunity to submit text questions to today's presenters by typing your questions into the questions pane of the control panel. You may send in your questions at any time during the presentation. We will collect those and address those during the Q&A session at the end of the presentation. Thank you to the State Bar of South Dakota for its support of today's program. I now would like to introduce our presenters. Nicole Tupman is Assistant General Counsel at Midco, where she collaborates with business leaders on contract negotiations, regulatory compliance, litigation strategy, strategic projects, and new product offerings. With a strong background in commercial and regulatory law, Nicole has developed a well-balanced blend of legal expertise, business operations acumen, and people and process management. She is experienced in analyzing and prioritizing information and offering accurate, practical advice while mitigating risk in a fast-paced environment. Nicole received her Bachelor of Arts with honors from the University of Chicago and her JD magna cum laude from St. Louis University School of Law. Prior to going to law school, Nicole taught special education with the Teach for America program in inner city St. Louis, Missouri. Nicole Mohning is a partner with the Cutler Law Firm. She primarily practices in the area of employment law, providing advice and counsel to both public and private employers on human resource policies and practices, state and federal compliance issues, employee benefits and leave, and non-compete agreements. She also assists clients with employment-related claims in the courts and administrative agencies. Along with her employment practice, Nicole is actively involved in litigating commercial disputes. Originally from Lamars, Iowa, Nicole graduated from the University of Kansas with a Bachelor of Arts in History and American Studies. Following graduation, she was involved in secondary and higher education, where she served as a teacher and in student services. Nicole returned to school at the University of Kansas School of Law. During her time at KU, she was the recipient of the H. Ross Hutton Award for services in the Legal Aid Clinic. She practiced in Kansas for several years before joining the Cutler Law Firm in 2008. And with that, here are Nicole Tupman and Nicole Mohning for today's presentation.
Okay, this is Nicole Mohning. We'll go ahead and get started. First of all, as he indicated, we are happy to be here today to talk with you all about some of the items that we've been dealing with respect to COVID-19 and employment matters, both within our law offices, with our clients, and then also from Nicole's experience as in-house counsel, how some of the very interesting things that they're doing at Midco that she's going to be able to talk with you about. As Cesar indicated, there is the ability to submit questions, so we would ask you to do that, because that was, I think, one of the primary reasons that we were both in wanting to move forward with this CLE for you all, is it gives the opportunity to answer some questions and answer some things that you are dealing with, unfortunately, through the chat measure, since we couldn't get everybody on video. One of the things that I think we'll start with is going over, Nicole and I sat down and talked about the most frequently asked questions that we are getting and issues that we are having to address both within our own offices and within from clients. And a lot of those are primarily derived around, for me at least, with the Families First Coronavirus Relief Act, or FFCRA, which provided the emergency paid sick leave and the emergency family medical leave for employees. And as you probably all know, that law provided for leave if an individual was diagnosed with COVID, had symptoms and was pursuing a diagnosis, was quarantined due to close contact, or was caring for an individual whose school or daycare closed. So that was the most, the last one was for sure the most used provision in the spring, and that has certainly popped up this fall as the kids have gone back to school and kiddos have been deemed close contacts. The most interesting thing that I think is I'm still running into with FFCRA leave are a couple of items. In that, one, there's still a misconception out there that if you have less than 50 employees, you are exempt from FFCRA coverage, which is not the case. There is a small business exception for entities that have less than 50 employees, but in that instance, you pretty much have to show that by granting the leave, you would not be able to maintain operations, and you'd almost cease to be able to move forward as a going concern. So it's an extremely high bar. But as recently as this past week, I had a client call and indicate that they were butting heads with an employee because they were adamant that they didn't need to provide her with COVID leave because they had less than 50 employees. So we still need to continue to get those, even the main items out. We're still waiting to see what happens with FFCRA leave. All indications are that COVID, while we're excited about the advances that have been made with respect to the vaccines and the distributions thereof, all indications are that we are still going to have COVID with us through the winter months. But FFCRA leave will cease to be available as of December 31st unless Congress extends it. And I think we're all waiting to see if anything happens this week, but as of now, there's been no action on the Hill with regards to stimulus or exceptions with that leave. The other main component that we're dealing with FFCRA leave then is intermittent use when there's the ability for remote work. There's a lot of inconsistencies, or individuals will say, hey, if the person can remote work, then they're not entitled to work, or they're not entitled to FFCRA leave at all. While the regulations and the FAQs put out by the Department of Labor may not be entirely clear, the Department of Labor's enforcement arm has made it crystal clear that if that person's ability to work is significantly restricted due to remote work, so they're usually able to work 40 hours, now they may only be able to get in 15 through remote, that the balance they are allowed to get through FFCRA leave if they have the time left after their 2 weeks of emergency paid sick leave, and then the additional 10 weeks for the care of children, which is used in conjunction with FMLA leave. So lots of things going on there with respect to leave. Nicole, do you have anything to share with respect to issues and best practices that you've been working on within your organization for COVID leave or FFCRA issues?
Yeah, no, thanks, Nicole. I think you really gave a nice overview and background there. We've had, obviously, like all employers, been faced with this. We have not really had any concerns or issues. We know that we're covered by it. We do provide some additional paid leave outside of the COVID required leave. So we have some additional leave for our team members, flex time if we can, especially those of us, like me, who work in an office, who aren't out in the field and can flex time. has really been a benefit to the company. But that, once we understood the rules and it were, private attorneys like Nicole and her firm and other firms that provided us that guidance, it's been pretty easy. But make sure you know the rules. I mean, we have the rules down, but I don't have a whole lot to add there. I think that's been going just fine. Having some flexibility is great, I think, for your team members.
Yeah, and with all of these items, and especially the Department of Labor has really promoted the idea of flexibility and giving your employees the benefit of the doubt when it comes to items like documentation. Yes, we expect the employees to be able to get a doctor's note, but if they provide the information that says, their doctor who ordered them to quarantine, the dates that they're supposed to quarantine, that's sufficient. Document it in your file, and that's what you need for your Department of Labor records, and that's what you would need also for the IRS, which everyone's moving forward with getting those tax credits as well. As we approach the end of the year, I think the last thing that I'll say with FFCRA leave is one of the questions that's coming up is, again, as we approach year end, is whether or not that leave is considered compensation for inclusion in 401k contributions, if they're determined on compensation. And when I contacted the Department of Labor to verify that, because of course the guidance is silent on the issue, they took the approach that it probably should be. I think I was told, we'll run it up the flagpole in Washington, but we won't expect a response. So when in doubt, err to the side with the employee. I think there was a question, but it popped away. So continue to submit those. There we go. The question that we had, if we're done with FFCRA leave, we're going to move on. The question that we've had submitted is, have you encountered a lot of cases where the DOL is asking people to return all unemployment because they've now been deemed ineligible? What do you advise the client to do? Yes, the short answer to that is yes. We have been in situations, I think our office has been contacted probably 2 or 3 times a week with individuals. We have gone through the appeals process. There are several individuals that are going through that process. What we would suggest is to go through the details. They're getting very technical, and I'm not saying this in a matter to be condescending or critical of the Department of Labor. I don't think anyone would have want to have been in the State Department of Labor reemployment office in March, April, and May. However, the situation is that they're finding very technical bases for post-payment determination of ineligibility, such as failure to reapply after the CARES Act went into effect, et cetera. So what we advise them to do is to really dig into the details, get a very specific rationale from the department as to what the basis for the denial was, and give your shot at an appeal. That's about the best that we can do. I can't say that we've been very lucky or fortunate in a lot of our appeals, but there have been some cases, and one thing that you really want to look at as well, in which they've asserted fraud with the individuals in their applications. In those situations, we have definitely gone into the details and fought that, because you just don't want that determination with respect to anyone's, I guess, moving forward. You know, the state have found that you've committed fraud against them if you're moving forward with jobs, et cetera. The next question, I guess, to go back for small employers, what pay is required for anyone that's covered under the FFCRA. So employers under 50 and employers up to 500, because after 500 they're exempt from the act. There is, under the FFCRA leave, the individuals are entitled to 40 hours or 2 weeks and 2 weeks is determined on whatever their regular schedule is. So if you regularly have your employees work 50 hours, they're entitled to 100 hours. If this employee usually works 15 hours, they're entitled to 30 hours. And they are entitled to pay at their regular rate as defined by the FLSA. So we're back to that fund determination like you would for overtime. Up to those hours for, like we talked about, leave for quarantining if they're sick, etc. The exception to that is if they are there to take care of someone else. So if there's a daycare closure, a school closure, or a child that is quarantined, the amount is 2/3 up to the cap. So that's what paid leave is required under the FFCRA. There's no exception like we would for regular FMLA for those additional 10 weeks, but that does not, small employers still are not covered for regular FMLA. So for example, if you had an employee that used their 2 weeks of emergency paid sick leave to take care of their kiddos that were sick, now they become ill, they've used their 2 weeks, they can't move forward. Says when you're talking about the Department of Labor regarding Families First Coronavirus Response Act, you're talking about the U.S. Department of Labor, not South Dakota, right? That's correct. We're talking about the U.S. Department of Labor. And when it comes to Family First Coronavirus Relief Act, CARES Act, any of those items, we're talking about the State Department of Labor when we're talking about reemployment insurance in that second question. So hopefully I made that clear, but we'll move forward. What medical documentation can you request? I wonder if you can clarify your question. What we can request with respect to additional leave, if it's just what can you request for FFCRA leave, it's actually fairly limited. You can request a doctor's note to verify their status or the dates of leave. That's what we've asked for. That's what we've indicated to employers that you can ask for. If you don't get those, the federal Department of Labor has been reticent to allow employers to deny FFCRA leave for the basis of not having a doctor's note. So it's really going to be on a situation by situation basis. But if you want to further clarify that question, we can go through that. But if someone is asking for FFCRA leave, if they give you the essential elements of, like I said before, the doctor's name or the provider's name, the dates that they're supposed to quarantine, when they were visited, etc., you pretty much need to move forward with granting leave. Okay, well, thanks for the questions. That definitely helps. Nicole, I think one of the things that I think is really that would be really good for you to talk about is the way that your office, because it is still working remotely, has really worked to try to continue to engage your employees and keep them included and moving forward when you're working remotely for now going on 8 months. So why don't you take that?
I will take that one. Thank you. So we started working remote in March. Anybody who was able to move remote, of course, we have folks who are in the field and who do customer installs and our construction folks. But most people have moved to remote. We are working remote for an extended period of time. I don't know that we have formal return to work orders yet. We have a phase approach. So right now we're in phase 1. So some folks can come into the office. Kind of depending on job title. And so there's that component on the remote side, but on the employee engagement side, we've had, you have to shift quickly, obviously, as a number of us have, to being remote and working remote and continuing work remote and those relationships, where you don't get to stop and talk to somebody in the hallway. And so we've worked on a couple of things. We've done increased training opportunities, and not just training on Midco's business, but training on, for example, there's a program if you start thinking that you're having negative thoughts or that you're thinking pessimistically, here are some tips and tricks for handling that. And we've seen some really good responses from employees on that they find training like that helpful. It's all optional, but just offering some additional resources. We also have a kind of belonging at Midco that we've been working on, and there's different aspects of that. But for example, we just had a company cookbook come out, so employees could give recipes, and we have now a community cookbook, and there's chats, and there's different groups. We do a lot of WebEx, which is our Zoom platform, and making sure that we've done an investment that we can get folks video cameras, and that's been really key. But also other items, it's nice to have sometimes a standing desk that can go up and down, the elusive uppy downy desk, if you will. So we offer those to employees as well, and that's been really helpful. It's also great to have that to reduce, claims from employees on any discomfort. So that's been helpful. But it's a lot of just talks, and it's a lot of being cognizant of what's going on and trying to give extra grace. And yep, an assignment didn't get completed this week, but you know what? It's not detrimental and it's not material. So just trying to give folks as much grace as possible. And we're going to see a lot of folks who aren't going to come back in remote, or aren't going to come back into the office. Excuse me. They are going to stay remote. A lot of people really like it. They get more work done, and that's great. And so I think you'll see a shift in a lot of employers. I don't think we're unique at all in that aspect, that some of the workforce might not return or might spend one day in the office. We have whole groups here who work better from home and they're happier. And so why not? We'll let them continue to work from home even when we do a full-scale return to work process. But I think creativity is key here, and a lot of communication and dialogue. If you feel free to reach out to me if you are representing somebody or if you work at a company and you'd like to learn more about what we're doing. I'm happy to share any details if that's helpful.
Perfect. We had another comment that came in that indicated that to go back to the documentation issue, that the FAQs for the Federal Department of Labor and the regs seem to indicate no right to a doctor's note. And I wouldn't disagree, and I apologize if I confused things there, but what in the conversations that I've had with the local Department of Labor office is that they've indicated that if the normal policies are for absences, et cetera, are ask for a doctor's note, that you can continue to do so, but leave cannot be declined should you not get it. That's the way that we've been proceeding. I would perfectly acknowledge that there are others that feel that you don't have the right to even ask. That's been the way that we've proceeded for the last 8 months. The abundance of caution to try to do our best to alleviate abuse. But again, I acknowledge you're absolutely correct. We may have skirted that one a little close, but that's I know the way that we've handled it. See if I'm okay. I think we've got all of the questions. One of the other questions that we get, or issues that we're encountering quite a bit lately, is testing and whether employers can test employees or require testing to come back to work if there's been a close contact. Our guidance in that has been to, while the EEOC has given some leeway with respect to testing and asking for more medical information during the time of the pandemic, a COVID test is still a medical test under the ADA, and there needs to be a legitimate business necessity for it. So any testing protocols that you put in place need to be applied equally to everyone. And we have then, the next question then comes up, and when I say everyone, apply to, the employees on a non-discriminatory classification. Don't be picking and choosing, as we always say. The next question then that came up was, if for example, you have an employee that wants to travel to a hotspot or out of the country, can we require them to have a test and to pay for it when they come back? And while that seems reasonable, we've been reticent to require any employees to pay for their tests. As you know, in South Dakota, we have a provision that says that the employers have to pay for the drug tests. While it's a bridge, it's not a direct corollary. We've indicated that if you're going to start requiring tests, that you should be the one to arrange and pay for them if you can, if you're going to require them. So that's kind of been our latest on testing. The most recent question comes up then with masking, of whether or not you can, every employer has the right to require masking. I know that we are utilizing masks in our office. Anytime you have to be, attorneys are outside of their offices or assistants are outside of cubicles. That seems to be a very consistent situation. If you have individuals that claim that they cannot wear a mask due to their a medical condition, that potentially would fall under the ADA accommodation protocols, and I'd have you walk through that provision. In talking with OSHA, they've indicated that, of course, a mask is not a respirator, so you still have that situation that you're not going to. And at the beginning, they had us go ahead and have individuals waive and acknowledge that it wasn't a respirator and go through that protocol. I can't tell you, to be honest, if they're still recommending that or not. And I think the last thing then that I wanted to go over with those types of things are with masking, testing, and contact tracing and close contact definitions. We get the question because of the way that the school is identifying, some school districts are identifying close contacts as if you were wearing, if the individuals were wearing a mask, or both individuals are wearing a mask in some districts, that they're not considered a close contact, and can you institute that policy within your workplace? While you certainly can, that technically still is not falling in within all of the CDC guidance. So there is a risk that if you do that and you have an outbreak, that you could have an OSHA situation on your hands. You still all have, and our clients have the obligation that if they have an employee that tests positive, to do a minimal a reasonable investigation to determine whether or not that exposure to the virus occurred during the course of their employment. And if it's more likely than not that it did, after asking basic questions, that becomes an OSHA reportable event. So if there's one thing that I think that's one of the things that's slipping through the cracks, that would be one. Moving on, I think that as we all get in, we just had Thanksgiving and there was lots of discussions as to how should employers handle travel. I know we had that discussion in our office and I think I got 10 phone calls from clients in the week leading up to Thanksgiving of, can we require employees to quarantine if they're traveling? And this was a lot easier back in March and April when you had some identifiable hotspots, and it could be, hey, if you have someone going to Florida or New York, that's a hotspot. You can require, quarantine or have them be out of the office when they return or out of the workplace. It's a little bit harder for us right now to make those decisions, at least for me. And I'd love if you guys want to put in the chat how you're all handling that, or the guidance that you may be giving when we're one of the hotspots. So it seems a little bit difficult to say if someone travels to Minnesota or Iowa to visit family, that they should need to quarantine for going out of state. But if you travel within the state, it would be excluded. So it's a really hard line, I think, to draw when it comes to travel these days. And we seem to do it more of if you're going to be on a plane or if you're going out of the country. So those seem to be the two indicators that we see more often used as a basis for quarantine. Nicole, how are you guys handling travel over there?
Yeah, so that's been a tricky one for us because we have a 5-state footprint, so we travel already within the 5 states, and then we attend, just as the nature of our job, a lot of out-of-state trainings and trade association conferences, and of course meet with our regulators in DC. So what we started out doing is we had, like you said, Nicole, we had areas where if you're coming from these hot spots, you're essentially quarantined. We now don't have any of that. We ask, you have to get prior permission to travel for business. And then we aren't monitoring personal travel. We're asking people to use their best judgments right now. We aren't requiring any disclosure of personal airline travel. We're just asking again for best behavior. Kind of becomes, it's a really tough line to walk. We are considered essential workers. So even though, for example, we have services down in Kansas, the state of Kansas, that has quarantine orders from North Dakota and South Dakota, we have had to work with local officials there to have our folks travel to do necessary repairs on our infrastructure in the state. And so there's been some workarounds like that, but beyond that, we just take more the approach now. If you are somebody who is in the office, we're asking you to take precautions in your private life. It's difficult to enforce that, of course. We also, I think, and I've seen this a lot from other attorneys who are on the in-house committee that I'm on for the state bar, is watching what your employees say about masks in the public. We require masks. So if I'm outside of my office, I have to have a mask on. We have limited bathrooms and all of that. And there's an expectation that if you're a public-facing employee, like a spokesperson, that you are upholding the company's stance. And so I don't have good guidance for you there. Just it's an area that I've heard others as well in-house, that that's one that is really tough. And I think trying to set the culture, and this is what we adhere to, is helpful on that. But certainly all of the posting on social media and just the political nature that masks have become has added some additional speed bumps, I'd say, in getting everybody on board with masks. But yeah, travel for us, we aren't otherwise traveling right now. There are very few exceptions made. It's really only for critical infrastructure purposes.
Okay. We've got a question, and I'm going to be the first to admit that I'm not entirely sure what we're asking, and if there are specific tax implications, I'm not going to be able to help you with that. So the question was the requirements for a work from home stipend to cover reasonable and necessary expenses. Obviously, a work from home stipend is something you can have as a fringe benefit. The tax treatment of those is my understanding that they have been that they can be taxable, but I am going to have to, sorry, I'm not going to be able to help you much on that one. Obviously, if you have a stipend and you do allow those, that you're going to want to have it be to cover the expenses as much as possible, and to have that pursuant to a policy and how you can deal with those. But Nicole, do you offer those at your?
No, we don't do any kind of stipends. We are buying employees desks for at home, and then we just if you don't stay, you have to stay 6 months to cover the cost of the desk. Otherwise, we ask you to pay the prorated amount back. But that's really about all we're doing. We're not giving any other kind of stipends because we provide all other equipment besides the desk, I should say, and desk chairs. And we really do the desk chairs too, because that's trying to obviously limit liability of any kinds of workplace issues or injuries on the job. And so some of our employees do get desk chairs, or you can ask your supervisor, and we have a lot of desk chairs to be able to give people. But Beyond that, we're not doing any kind of stipend, just some basic office equipment.
Okay, yeah, no, that sounds good. And I think everything is going to be completely specific on the on the details, and obviously, and you might be able to work that in the same way that you do cell phones, but I'm working from there. We have no more panel questions, so if anybody has those, go ahead and send those in, because we were planning on a bunch of them. To kind of fill up our time here. I think we've talked about close contacts, excuse me, and quarantining. For sure, those are the things that we've had the most impact with. There's always going to be expect the unexpected, and every case is a little bit different. I know that one of our issues has been kind of the hard rules with the CDC guidance. And, you know, we had this situation come up in our office twice in the last week with our own employees of, if someone tests positive, excuse me, for COVID, you know, they run their, we go the 10 days from the first day of symptoms, or from, you know, positive test, you go through the time period post-symptomatic and you return them to work. What was interesting is the manner in which the CDC requires that if you have an individual that lives with a person that tests positive, and they can't completely isolate, that their 14-day quarantine period doesn't start until the positive person gets to leave the household. So you could have a situation which, you know, with an individual, if the child is positive, you could have a parent that could be stuck in quarantine for quite a while.
Yeah, that's been one with the changes in, especially I think the Sioux Falls School District just changed that. I know our daycare just changed on the time frames, and so we have really seen a change in people's availability if their children are in quarantine in the time period of coming back to work. So again, trying to be flexible, but that's been one that's been challenging.
Okay. Off-duty behavior and COVID in the workplace. That's always a fun one. We have dealt with it. It's very hard for you to discipline, or employers to discipline employees for off-duty conduct, especially if it's legal conduct. That being said, so if they go out, they may be engaging in what you might characterize as risky behavior, get themselves, you know, exposed to COVID. Can you take disciplinary action? Probably not. Where we have come down on this, or where we have drawn a line, and I have counseled a client once to be able to take disciplinary action, or at least moving forward to document it in the file, is a situation in which they had an employee who was a public-facing employee that was involved in hosting what they've called, you know, a COVID party, in which they were intending to expose each other or other people to COVID. And she knowingly exposed herself, but then reported to work and was public facing. And so in that situation, we did advise them that they could document the behavior, and that she violated their established written COVID policy regarding not disclosing contacts, and provided a threat. So in that situation, we did. Otherwise, I think it's really hard to do that with those situations. Nicole, how are you guys handling it over there?
Yeah, so we do discipline for like technicians or engineers who are coming into contact with customers in their homes or at businesses. We haven't had it come up, but have the policies in place that if you are not wearing a mask and following Midcoast rules, it is disciplinary because you're interacting with the public. We haven't had that issue come up. We have had some people attend events and have maybe not worn their mask the whole time. And we now have a policy in place to talk about that in the future if that happens. But that is that, you know, we wear our masks in public because it's required by our states and it's required by our company policy. And so we've been policy heavy throughout this period and heavy communication. So we get a lot of communications. We have a prevention team. They deliver all the communications on behalf of the company, so it's consistent. But we are policed up to be able to provide or to be able to discipline an employee who's not following the rules in public. We don't touch as much the social media. That's not necessarily disciplinary, although we have had some leaders reach out to their team members and say, hey, this isn't Midcoast values. So let's be careful when you're posting on here because you have down that it's such and such position at Midco. So I had some of those tough conversations, but it hasn't risen to a type of discipline.
Let's see. Off-duty behavior. If we've already covered, let's see, what is an employer's obligation to notify staff if there's an employee who tested positive for COVID? The obligations, I think, are not entirely clear unless you have some individuals that are close contacts. And obviously these are when you would hope that the health department and whatnot can step in, but as the numbers have increased, that's been a little bit more difficult. We've erred on the side of caution, but still maintaining privacy, that you can identify that there is someone who has tested positive, and you can ask that the positive person who they may have had contact with, so that you can move forward with doing the close contact evaluation within your workplace. But there's not, past that, I don't think you don't have a quote unquote obligation to notify staff if there's an employee who's tested positive, if there hasn't been a close contact or within the realm. You certainly can, as long as there's a not identifying information, kind of the same notifications that we're seeing with the school districts.
Yeah, we've just been notifying if we know it's a close contact. Otherwise not been, I don't know that if it's not defined as a close contact, I'm not sure that we've been doing any kind of notifications really to protect our employees' privacy.
Let's see, the next one, have we run into any contradictions between the ADA and this area of the law and COVID? I don't know if we've run into contradictions. It has made it, COVID has become an area in which the individuals have had to identify, I guess with staying home at the beginning when there wasn't a quarantine order, or making modifications for exposure if someone is higher risk, and you work through the regular ADA accommodation process. I don't know if I'd run and say that that's a contradiction. The EEOC has definitely then lessened the restrictions on inquiries, testing, et cetera, so that we can address the pandemic. But I don't know that there's specific restrictions or contradictions. Let's see. Okay, so there's a question of how FFCRA leave and the additional 2 weeks of paid time, but not clear how that interacts with paid time the employee already has. can the employer require the employee to exhaust existing sick time before using the FFCRA time? No. The answer that we've gotten from the Department of Labor and the guidance on that is generally no. They're entitled to use this prior to their PTO. If they don't have any left, then they can use their PTO, vacation, or sick leave. Or you can use their vacation and sick leave to offset leave if they're receiving leave at 2/3 pay. But that is, it can't not be required. Explain again, can an employer require quarantine if they travel for business and personal? If you do require quarantine, technically, I suppose you can, if you have a reasonable basis to do it. Some states, for example, like Nicole was talking about in Kansas, where if you're coming from South Dakota, then you're required to quarantine. So if someone leaves, they'll have to do that under the state guidance. It becomes a little bit, technically you can, but if you're going to deprive them of pay, I think it's going to be a case-by-case basis, in which if that person makes the decision to travel, you can make a distinction, whether it be air travel, et cetera, in how they're doing it, that exposes your workplace to a higher level of risk. Then maybe you can move forward. Hopefully you can try to do some sort of work from home, but you can, if they travel for business and you require quarantine, I would think that there's going to be some pay issues and some just from an equity standpoint of if you're going to require someone to travel for business and then quarantine them. Let's see. Can an employer require an employee to use personal leave if they travel for personal leave to a hotspot? Obviously for the travel, when they come back, yes, you can. If you're going to require a quarantine, the problem that we're running into, to be completely honest, in South Dakota with this is that we are the hotspot. So it's really hard for individuals to come up with a rational basis as to how travel within the state is any worse than sometimes travel out of the state. You really just, it's a case-by-case basis. Let's see, what can an employer do if they know an employee is a close contact and they aren't quarantining or isolating? If you can verify that they are a close contact, or they've admitted that they are a close contact and they do not fall under any of the exceptions, for example, if you are an essential worker and healthcare worker and you are a close contact under certain conditions, if you're masking, maintaining social distancing, et cetera, under the requirements with the CDC, you can be out and about. So, but if they've had that contact and they're not essential and you are in the office, you can, I would think, restrict them on a basis for to maintain public health. I haven't had that one come up yet, other than the one that we had the close contact who, I guess she did show up and we did discipline her. Nicole, have you had anyone that you're in close contact issues?
No, not that I know of. People have been pretty honest about if they've had close contact.
I think now we're starting to see with COVID fatigue and with people have already using their FFCRA leave and not wanting to use all their own paid leave, that's when we start to see it a little bit more, becoming a little bit more difficult to enforce that. Have we found any HIPAA versus COVID issues? If you are a HIPAA covered entity, healthcare employer, et cetera, throughout dealing with your healthcare plan, the addressing COVID would be covered the same as any other medical condition. So I don't know that we've dealt with any specific COVID issues, but it does become a little bit harder just with the sheer numbers of and issues that you're dealing with. Obviously, as we talked about before, notifying who if an individual is COVID positive, et cetera, that for most of us as employers will fall under just our general privacy policies. Oh, correct. I think I may have been on. Nicole, as we're wrapping up, is there anything else that you'd like to add?
I think one thing I would add is I've been trying to seek, resources for, here at Midco. I found that other attorneys in the bar have been so helpful in providing advice, and just to continue to do that, the in-house committee has been active. We had calls when the pandemic started, I think every other week, so we could all chat together. But there's a wealth of experience here, so just don't be afraid to reach out to people if you have questions. And I know Nicole and her firm have done a lot of work, as have others, but there's some really good resources here.
Okay. Yeah, and I would echo the same. We're constantly checking CDC guidance, Department of Health guidance, trying to stay up on what's happening. I think we'll see a lot of, if we don't have anything that happens on the Hill this week in Congress with respect to stimulus, I would expect to see something in January. So we'll have the big flurry again as to whether it is just a reauthorization or a renewal of the FFCRA type leaves and an extension thereof, or whether or not we get something all new. Hopefully not all new. So we'll be moving forward with that. But thank you all for your questions, and we hope that everyone continues to stay healthy and we make it through the winter.
And thank you, Nicole Tupman and Nicole Mohning. If any of those in attendance have any additional questions, please contact the State Bar at info@sdbar.net, and we will get you directed to our presenters. Once you leave today's webinar, you will receive a survey on the presentation, and we would appreciate if you would complete that and provide your feedback. On behalf of the state of South Dakota and the CLE committee, thank you for joining us. And again, thank you to our presenters, and have a great rest of your day.